You the clown. That's what you. Why don't you call me a cardboard bishop now? You tough? Call me a cardboard bishop now.
He's not gonna call you that.
Huh? Look on Facebook Live. Call me a cardboard bishop now. You clown. That's what you are. You clown. That's what you are. Why don't you say what you say on Facebook Live, sucker?
No.
Got it?
Yeah. So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit of conflict or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge, they don't know they missing. Got a couple current events that you like, wanna know about law from the eyes. Tired of all these blogs running lies because their agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
Hello, everyone. It's Pam Esquire, also known as your law intellect / social media lawyer. Thank you guys for spending your lunchtime with me. I truly appreciate it. Every time I hear that song, my son really did a really good job on that rap. I'm so proud of him. He says he's retired, but we're going to bring him out of retirement. I had to almost, beg him to do his rap for me. I had to say it was the birthday gift. So y'all encourage him to keep on going. But anyways, shout out to all of you, the intellects. Welcome to all the new subscribers. Welcome back to all of my day ones, or the ones that have been following me. I said that I was not going to do any videos on Whitehead this week. That's what I said to myself. I was like, I'm so behind on following up on all my other stories that I just can't do it. But then everyone kept emailing me, DMing me, asking me all these questions where I was like, you know what? I might as well just go ahead and go live. So, and then I also was looking like, you know what? I'm going to end up getting behind if I don't go live because it's so much information. We have various cases that we are following. I am going to try to catch you guys up. And also if you guys have any questions, because I've watched some other content creators, their lives, and we've all been following this for so long that I think some people are just now picking it up. So there's some misinformation that I've seen, and I correct it whenever I can correct it, but of course I can't always correct it. So I've been in some, supporting other content creators that have come with some, some information. A lot of information that some of the information that they're talking about, I may not have necessarily reported on because, again, my focus is more on the legal cases and the documents. It's not really on the personal life or, and then you have some content creators that are all encumbrance and where they're reporting on everything. So that's that. Let me speak this. You guys been in here for so long, waiting on me, and I appreciate it. I do not take that lightly. I do not. You got before I started, I was getting cash apps. I'm like, see, you guys make that come into fruition. He said that we make hundreds and thousands of dollars off his name. I've never made hundreds of thousands. I've never made tens of thousands. I've never made fives of thousands. So I don't even understand where that came from. But if you guys feel so inclined in your heart to make that a reality, by all means, go ahead. I appreciate it. I appreciate your time, because that's what I get paid for, is my time. So I appreciate everyone taking out the time to come to my platform. And of course, all those that have financially sold into the platform, I appreciate that too. T. Trista, good to see you. Chef Don Don is in the house. He said, we are here. I could not wait. Butchie's wife, hey. Baps, hey. You said shouting from Saginaw. Yes, Saginaw is in the house. I'll be in Saginaw this week too. Please, not for Whitehead, but please be something else. Well, it can't always be bad for him. I mean, he's gonna get little breaks here and there. I have to report everything. I understand. I've seen people with saying, "Oh my gosh, I have anxiety just thinking about something great happening." But we'll talk about that first and get it out the way so you guys can relax. Hey, Cupcakes. You said good morning, good afternoon. Yes, please hit the like button. Thank you for calling me a queen. You're a queen yourself. Cynthia said it's probably more the same, but like, I hope that the church situation, I've come to the conclusion that I'm going to have to do a whole entire separate video on the church because it has gotten lost in translation because I focused on the eviction on purpose because we have orders and we have everything that gives us a path that we can all follow as to why they should not have been locked out of that building where they were worshiping. The ownership portion is a whole nother monster. And as you'll see when we get into that portion of today's live, it's still being litigated, obviously. There's still court cases. So, hi, Shelly. And Two Sweet Lives Live. Listen, thank you so much for the cash apps. Thank you, Cheryl, for the super sticker. Look, I don't have, like I said, the fancy stuff that Chef Don Don has, but I was like, let me put something up. Thank you guys so much. I don't even have a beat. I know I didn't like any of the beats. I'm gonna have to have my son do it. But thank you so much for the super chat. I appreciate it. This is courtesy of Chef Don Don because he got the bop when everybody gives, and I gotta make you guys feel special too because I appreciate it. Hey Kwame, thanks for checking in. Brittany, thank you so much. Of course, Dev is in the house. Sheila. Let's see. Oh my goodness, this is a lot of you. Well, it's 461 in here already because we try to mind our business, but then they make it our business and then they get mad when I report on the business. But it's documents, it's legal records. So thank you so much. You said I love the fact that your content delivery is well rounded. Back to the clouds. Have a great show. Thank you so much. I totally appreciate it. So y'all get to see that again. I might not do that for everything because mine is a little longer than Chef Don Don's. But I like that he had the bop. So that's courtesy of him. You said Chef Don Don has a bop that I wish will play when I pay my bills. You said as long as Whitehead don't get his own the building, I am good. No, it's not. No, not the building, not the building. So as you guys know, we are covering several cases as it pertains to Bishop Lamora Whitehead. Some of you guys get mad when I say Bishop, but I'm just going to address him how he wants to be addressed, So I say that every now and then. So on the last video, what we're going to do is we're going to circle back to the federal case. We all know that he is currently been indicted, innocent until proven guilty. However, he is going through all the processes that you go through when you get indicted. That includes writing motions. In one of the lives that we had, there was a motion to suppress, and we covered that too, where his attorney was trying to suppress the warrants that were issued, saying there was no probable cause and other reasons. And the reasoning is if you suppress, like I told you guys before, if you can get the warrant suppressed, then anything that is derived from that warrant is considered fruit of the poisonous tree. We even went over that case in that video when I figured out what the case was. It took me a minute to remember because we learned it in law school. So what you do as attorneys, it's almost powerful, the course, honestly. You always try to suppress, if you can, and say that there were some illegalities as to how you were able to get this warrant and that the warrant didn't have probable cause or whatever issues you can find. So his attorney did that, and we went over that, if you guys recall. Hopefully, you guys that are in this chat remember that. We went over that. But then they had a deadline of March 15th of 2023. On March 15th, a motion was filed. The government responded. We went over that. The government showed a lot of deficiencies and flaws in their argument, as of course they would, because they're going to do the response. They also did what we call a sir reply. It was some back and forth. So Whitehead did a reply, and I think the government did a sir reply in this motion. So that was due on March 15th. Well, you guys know there was a superseding indictment, which is basically another count was added onto the indictment. And that was the count related to allegedly falsifying documents in order to obtain the loan of the home that he resides in New Jersey. Well, of course, when that happens, it knocks all those dates around. So now he needed, his attorneys were allotted time to do any motions related to that superseding indictment. So that was due on May 1st. Now, we all know, we also covered that prior to that, or around that time, his attorney withdrew. Now, this is the attorney that's done a lot of his civil work. He also was doing criminal work. We went over a lot of the motions that he filed as well on previous videos. So to say I'm not well-rounded is just not accurate, because if it's filed, I'm going to go over it. I don't just pick and choose the paperwork. But nevertheless, people see what they want to see. So we went over those motions as well. He withdrew. Now, on May 1st, I hope you guys are following me. On May 1st, Whitehead that was his deadline to file motions related to the superseding count. Okay. When May 1st came, his attorneys that are still still his counsel, Don Florio and her firm, they filed another motion to suppress. Now, in this motion to suppress, they pretty much beefed it up a lot. If you remember the first one, it was like it didn't have the affidavit affine to what they're saying, which is what you're supposed to have. The government essentially called out a lot of the flaws in the first motion that was filed. So essentially what they did was, when they filed the May 1st, which was supposed to be related to the superseding indictment count, that one count only, they beefed it up and they kind of talked about everything all over again. So I thought it was interesting, but let me tell you why they said that they pretty much were doing this beefed up, where they were adding all of the claims. Okay. So I tried to redact as much as I could, but they had so much information on here related to phone numbers. So they go through all of the counts again. And they go through all of the counts again. Okay, let's stop for one moment. We thank you for the blessing here. Thank you for using your voice to expose this criminal. Church hurt is real, and he's got a lot of victims who are sitting, watching, and applauding you and some of the other creators for your work. Thank you. I appreciate that. Because it gets rough out here. You know, I got dragged on the internet, right? But we gonna get to that in a minute. Because I was just doing the paperwork and you got mad at me and just anyway. So when they do this motion, right? This was filed on May 1st. That's why I told you in a minute, if I don't go over some of this stuff, it's going to start getting behind. So the procedural history is very, very interesting. So we're just going to read this portion because the motion to suppress is very similar, except it's beefed up with case law and whatnot. But it kind of has the same premise and argument. Plus, they have an affidavit attached from Whitehead. So it has these motions are submitted related to the motion schedule set by the court and related to the superseding indictment S1. A motion schedule was set in this case with defense motions due on March 15th. So remember, that was the one we went over. That was the one related to the original indictment. After that motion schedule, the first schedule was set. But before the motions were due, a superseding indictment was filed, adding a fifth count to the indictment. A motion schedule, the second schedule, was set as to count 5 with defense motions due on May 1st, 2023. Then co-counsel Brian Ponder Esquire filed a motion for an extension of the first motion schedule to align with the second motion schedule. The government opposed the motion and the motion was denied in the afternoon, March 15, 2023. So they denied the motion. Around 4 p.m. on March 15, 2023, attorney Declan J. Murray, Esquire of the Dawn and Floria law firm, upon learning that the motion for an extension was denied, called attorney Ponder, who had been tasked with completing the motions, and asked that attorney Ponder send over the motions so that attorney Murray could edit them before sending to attorney Florio for approval and submission. Attorneys Murray and Florio had not given any reason to assume that attorney Ponder, who has his own practice, was not capable of completing the motions and had allowed him to do such work without micromanagement related to timeliness. During that conversation, attorney Ponder stated that he had not started the motions. Attorney Murray then undertook the writing for the motions to ensure that they were submitted by the deadline and not precluded. As a result of this, the motions pursuant to the first motion schedule in this case were written in approximately 7.5 hours. So they find out that the motion was not done by the former attorney, according to them. This is their rendition. They find out that this was not written, so then they hurry up, as some of us attorneys had to do, and you start trying to hurry up and get it done. The motions herein contain motions related to the search warrants that were discussed in the first motion, but are included here in the interest of fully preserving all issues as they relate to each count, to include relevant exhibits and to avoid any potential appellate issues. In addition, there is reason to believe the evidence related to the charge in count 5 was obtained through the use of these warrants. So this is now 20-something pages when the other one was less than that, way less. It might have been like half. So as you see, when they submitted this on May 1st, they also added more information because the government, if you guys recall, were making statements or letting them know, like, it wasn't even an affidavit attached, like it wasn't even exhibits attached, like they were pointing out whatever the flaws were in the first motion. So it looks like this motion, they're trying to talk about this superseding indictment, but then they're also going back to the first indictment, the original indictment, I should say, and discuss that as well. So y'all follow me? Oh my goodness. Y'all hit that like. Hit it's 665. Y'all hit the like, subscribe if you haven't done so already. Hello to everybody. Okay, let's get back here. The QT, they're filing a lot of motions to suppress. It's not looking good for them. I mean, how else you gonna say any evidence they got from it? That's what you do as a defense attorney. You need to try to suppress these warrants. Like, that's what you try to do. So anyways, So you guys say yes. So you guys are following me. I'm gonna make sure I haven't lost anybody. Yes, you guys make those likes. Please match all these people that's in here. I appreciate it. So let's get back to business here. I feel like I'm teaching a class or something. So after this was filed, the court issued an order. So this was the order that was submitted, and this was submitted on May 3rd of 2023. So they say, whereas defendant's motion with respect to counts 1 through 4 of the superseding indictment were due by March 15th, 2023, and defendant's motion with respect to count 5 of the superseding indictment were due by May 1st, 2023. Whereas on May 1st, 2023, defendant filed a second motion seeking suppression of evidence from several search warrants. And then it has the search warrants in the page. It is ordered that defendant shall file a letter by May 4th, 2023, explaining whether the second motion, including the arguments challenging the warrant, relates uniquely to count 5, which would obviously make it timely because it was filed on May 1st. And if it does not, why the second motion is not untimely. It is further ordered that defendant shall file the warrant and any additional exhibits under seal by May 4th, 2023 by mailing the papers, and it tells you where to mail them to. So there were exhibits that were attached, but we don't have access because it's under seal, because this is, the actual warrant request. So, of course, a letter was filed. Well, Ponder was able to withdraw. I guess I got that part. That was May 1st, 2023. So the court ordered and allowed him to withdraw essentially on the same day. Exactly the same day that the motion was due. For those that didn't know, he was able to withdraw, so he is no longer the criminal attorney. Let me find this last letter real quick. Hold on, I thought I had it up. Hold on one second, please. You guys be patient with me. So you guys talk amongst yourself, talk among yourself. I know we're family around here. So you guys, check up on everybody, make sure everybody's having a good day and all of that good stuff. Did I not put this in? Wait a second, guys. Okay. So essentially, this letter was actually filed on May 4th. I did May 8th. I'm using this one because at the end it got the court's order. And so they give the reason, they being the defense, Lamar Whitehead and his attorneys, they submit this letter at the request of the court. As they say, this is their preliminary statement. So they say, in January of 2023, a motion schedule was set in this case with defense motions due. We just read all that, so I'm going to skip that paragraph. He talked about Brian Ponder with the extension again. Okay, so this is a little bit different, so I'm going to read this paragraph. Around 4 p.m. on March 15th, attorney Declan J. Murray, Esquire of the Don M. Florio Law Firm, upon learning that the motion for an extension was denied, called attorney Ponder, who had been tasked with completing the motions, and asked that attorney Ponder send over the motions so that attorney Murray could edit them before sending to attorney Florio for approval and submission. Attorneys Murray and Florio had not given any reason to assume that attorney Ponder, who has his own practice, was not capable of completing the motions and had allowed him to do such work without micromanagement related to timeliness. In addition, attorney Ponder, not attorney Murray or Florio, had submitted the request for an extension of the motion schedule without consulting either Attorney Murray or Florio. There was no reason to suspect that Attorney Ponder had asked for an extension of the motion schedule without consultation unless he was the one completing the motions. During that conversation, Attorney Ponder stated in sum and substance that he had not started the motions. Attorney Murray then undertook the writing of the motions to ensure that they were submitted by the deadlines and not precluded. As a result of this, the motions pursuant to the first motion schedule in this case were written in approximately 7.5 hours. On May 1st, 2023, defense motion pursuant to the second schedule were filed, many of which dealt with matters addresses in the first schedule. On May 3rd, 2023, the court issued an order instructing the defense to file a letter related to at least in part the issues of timeliness. So they say their argument. The motion relate to count 5 and are therefore not untimely. Hold on one second. Let me make sure I no phone numbers on here because all this stuff got all these phone numbers. I don't see it. He probably don't even have these phones anymore. I really doubt it, but still, I just feel some kind of way putting some phone numbers on my screen. That just doesn't seem right. Okay. 731 of you guys, please make sure. I should have some good likes at this point. 731 in the chat. Okay, so the motions filed were not untimely as they do relate specifically to count 5. Count 5 states in relevant part that, quote, in an effort to obtain $250,000 business loan, Whitehead made material misrepresentations regarding the finances of Anointing Management Services, LLC. Some of the warrants specifically, and they talk about the search warrant that was at his home, states that the allegedly illegitimate small business loan application is the basis for the search. It is unclear how this application or information related to it was obtained, but it seems probable that this was based upon information in the phones that have been seized and searched pursuant to prior search warrants. So they're essentially saying that the old search warrants may be related to how they got this information for this new, for this superseding count. Essentially, they're trying to tie it all together because this motion is way more extensive than that first one for sure. Okay, so that's pretty much what they're saying. Won't gotta read all that. So B, where the motions to be considered untimely, there is good cause for the court to consider the motions. So they're saying even if, Your Honor, you find that this is untimely, we have good cause to file this. And this is what they say. So Federal Rules of Criminal Procedures 12C3 stated in relevant part that, quote, if a party does not meet the deadline for making a Rule 12B3 motion, the motion is untimely. But a court may consider the defense objection or request if the party shows good cause. Were the court to feel that these motions were untimely, the court will be allowed to consider them if the defense shows good cause. Good cause can be shown here. So they saying, Your Honor, even though we might be late, we got good cause. We got a good reason why we are late with these motions. So their good cause is as follows. Were the motions to be denied as untimely and there to be a conviction, there would almost certainly be an appellate issue related to the matter of ineffective assistance of counsel on the part of Brian Ponder for not starting the motions. Considering these motions avoids the risk of any collateral appellate process and best preserves judicial economy for ensuring the finality of any disposition. This would also comport with the due process rights of Mr. Whitehead. He should not be penalized for an error on the part of counsel. This is especially relevant with regards to Section A of the second motion, which relates to a warrant that was not challenged in the initial motion. The defense would obviously consent to the government having as much additional time as is necessary to address the motions. And so they give the case law for their rationale. They said the matter here is analogous to United States v. Alawi, and they give the site. In Alawi, the court stated that they were concerned on these facts about the balance between procedural rules, important as they are, and a defendant's constitutional rights. And this is United States v. Ocean, which is an unpublished opinion. They got the Westlaw number, so it's unpublished. Unpublished opinions are not considered, what's the word I'm looking for? It's discretionary. It's not precedent. Like, the court can consider if they want to, but it's not considered law. And I don't know why the words are not. And I use it in my motions all the time. Every time somebody look like they want to use an unpublished opinion. But I'm sure it'll come to me. Considering defendant's motion, even though it did not comply with the local rule regarding deadlines for filing supportive affidavits after balancing the local rule against the defendant's constitutional rights. And then they have a footnote that says it goes without saying that counsel has no intention of repeating this situation in this or any case. Oh. So that was what they said. As in Alawi, the balance here would lean towards the rights of the defendant. The motion schedule set by the court and associated procedure rules are incredibly important, but the question of Mr. Whitehead's constitutional rights is likewise important. The error here was made by defense counsel, not Mr. Whitehead. Yet, if the motions are not considered, it is Mr. Whitehead who will be impacted by the decision. And then it just goes through the balancing factors on why. So, my question to you guys, let me look. Let me look at the comments. Hey there. What's up, Pam, in the chat? I'm in Queen Supreme Ninja watching. I see Don Florio in driving the bus and he's running Prime Ponder over. I guess in all fair love and war. Yep, pretty much. Thank you so much for the super chat. I appreciate it, Mr. CKB. Yes, all my moms. Yes, thank all of the donations. We appreciate it. Please get the likes up, guys. So I'm going to be honest with you guys. I have mixed mixed feelings about this situation because I still, at the end of the day, regardless of who the defendant is, I have to be fair. I can see both sides of this situation. And the reason why I say that is, remember when I told you, we all know, it seems like to me they're making it as if they didn't know that Ponder may or may not have been able to do this criminal stuff. That's my interpretation. We all know he was a civil attorney. Do we not, in the chat? Like, we all knew that. So when he was on there as a criminal attorney, we were like, okay, so why is he on as a criminal attorney? We were all kind of asking that. And I said, I've done criminal and I do more civil now, and I actually do a combination more because I try to do wrongful convictions. So I do wrongful convictions. And you do it from the criminal realm, you got to try to get them out. Then you sue from the civil realm, which is like a civil rights 1983 case in federal court. But when I had any case that I had never done before, regardless of whether I've been practicing, if somebody comes to me and say, hey, Pam, I want to teach you immigration, I'm not an immigration attorney. So because I'm not an immigration attorney, if I feel like that's an area that I want to learn, then I go get a seasoned immigration attorney that I sit next to, and I'm second chair. I'm going to watch you. You may let me get the hang of it, do a little direct examination. You kind of critique what I do. Of course, I got to learn, do my continuing legal education so I can make sure I'm well versed. And you probably want to do that 2 or 3 times. So I told you guys, if you recall, that when I first did certain areas of law, I made sure that I had someone that knew more than I did, or that's what they practiced. So I was like, why would so that's that. I think it was We all knew he didn't do criminal unless there's something we don't know. Right? Maybe he did do criminal and maybe we just don't know. But from what I understand, he was doing more credit repair and civil stuff that I've seen. So I see it from that end. But then as an attorney, like I was saying, when people come to me, and some of you guys know because you've come to me and you've asked me about certain issues in certain states, I give my disclaimer. Yes, I've done landlord tenant, but I don't do it all the time. So yes, I could read a statute if you want me to read it. And I don't practice in every state. And I have not done work in every single state. So, there may be differences in how the states handle it. But I'm very, very clear of what my limitation is. And there's cases I turn down all the time because I'm not, even though I'm an attorney, people just think because you're an attorney, you do every area. I don't know why that's out there. But when you take the bar, you don't even know. It's like 60 areas and you really don't even know which 10 they're going to put on there for you to have to actually do your test on. That's what makes one of the things that makes the bar so hard, because you have some areas that you're very strong in and you're going to have some that you're weak in. If somebody gave me secure transaction, taxes, all of that, I would be like, I don't even know what you're talking about. But people just think because you have the attorney label, you can do everything, which is not true. So I was very, very I'm not going to say concerned, but I'm saying as an attorney, I personally would not take on a case unless I knew what the heck I was doing. So that's why I said I can kind of see both sides. So let me see what you guys think. My neighbor is really got the car alarm going off. So anyways. Did you say credit score Esquire? I'm just saying, it's no digs because you guys know I said I don't talk about attorneys because even though everybody sent me all type of information and documents, I told you guys I wasn't going to be the one to do it because I know how hard you fight. You windmill to try to get this spot or to pass the bar. Law school is very expensive. A lot of us are still paying for it 10 and 15 years later. So I get it. I'm not going to do that. But that's what it sounds like. Their rationale was, according to this, is, hey, judge, if you don't allow us to do this, then we definitely are going to have an appellate issue if he's convicted, and we'll be able to, say ineffective assistance of counsel. I don't even know how that works when all you guys are working together, though. That's a very interesting concept just because I guess you're separate firms. Unpublished opinions are not. That's what I couldn't say. I couldn't even think of binding. That's exactly what I was trying to say. It's not binding on the court. It's a good thing that you're so smart. Thank you, Joanne. I appreciate it because I was really having a fog. And I literally say that every time somebody does an unpublished opinion. I'm like, in the court, you can just dismiss that because that's not even binding on the court. It's a good thing that Ponder is out because post-conviction issues could possibly get Whitehead off on technicalities. Great job. Yes. You think it was a plan from the beginning to stall? Is that what St. James said? That's interesting. New to Pam Esquire. I'm learning everything from her, so thank you. Oh, thank you so much. I appreciate it, Danya. Thank you for liking and subscribing. Don was the head attorney since the robbery, and she does both criminal and civil. So as head counsel, she would have known the legal limits of Ponder and all other attorneys on the case. But not only that, Jeff, when you're in a federal case, everything is e-filed. So everything that is filed, you know that it's filed. Right? It goes to if you attach your secretary, your paralegal, other attorneys that work in your firm, yourself, everybody gets these pleadings. So how do you not know when he was filing those prior motions, y'all didn't look at him to see, like, let's see, you know, how he's doing with this. So anyway, I think the other attorneys knew he wasn't really capable to handle this. Just listening to him on the live, anyone could tell he was not qualified for this arena. And it's okay. Like, you're not jack of all trade, master of none. Like, I did a lot of criminal in the beginning, and I started out with what we call high felony cases. I was doing, unalive cases. Like, that's what I was doing. High profile, but it was the attorney I worked for. So while most people might start out with a simple assault or trespassing, I started out kind of high up because I had a very seasoned attorney I was working for, and he did a lot of high profile cases around here. So I started out with the work that it takes for a lot of these cases. I've only done all the way, well, they pled. I've really only done one federal criminal. Well, I've done two federal criminal cases. So, but when I did my first one, and Dev is in the chat because he came to that hearing, and I think that was around. We had just got married, I think, and he just moved here because he's not from here. And I had another attorney on there. Now, Dev felt like, and he'll tell you that I could have just did it by myself because I did do most of the work. But nevertheless, I didn't feel comfortable because even though I had done criminal in state court, I didn't feel comfortable doing that in federal court, if it makes sense. I wanted somebody that had 20 years experience to tell me, like, yeah, Pam, or tell me what I'm doing wrong. The best thing, and I tell newer attorneys, if there are newer attorneys that are in the chat or in the bushes watching, you're going to make mistakes. Like, when I first started out, I remember I didn't know what allocution meant. And I had done it 1,000 times. I never use the word. So it was like, an allocution is basically before someone is sentenced, you're trying to tell what's so great about your client and why you should give them the most leniency, and you tell them their background and all of that. And it took I was probably maybe 1 or 2 years in. But when I went in there, it was like, I always did that. When I had cases, I always did that. But you have to recall, when I started out, we were trying cases. We were having such big felony cases that nobody pled. So I had to say nothing real nice about my client. Like, either you got convicted or you didn't. So it was like you had a sentencing memorandum that you would do, and it would weigh the factors and all of that. And you kind of let your client would talk. Your client would be the one that kind of talk. So when they used the word, it was like, I remember like a year, and I'm like, the judge was like, counsel, could you ready to allocute your client? I'm like, what? But I had done it all along, I just didn't know. So it's so many different things that, even though it seems minute, that you may not know what it is. So to me, it's always good. Even when I go to trial now, I don't go to trial by myself. I don't care if my paralegal is next to me. You don't do that stuff by yourself just because you never think that you're too seasoned or too old to learn. So this was just interesting to jump from different areas like this, related to him. But that's just my opinion. Nobody else has to, nobody else has to do that. So that's not on the court because he employed an attorney who wasn't fit. He has an entire legal team that's on them to collaborate. How is this on the court? Well, the court had to make a decision whether they agree, whether they wanted to take that risk that they go to trial. Like somebody just said when I put it on, our name escapes me already, but do you want a judge to dot their I's and cross their T's so it's no technicalities to get them off? So anyways, so let's go with what the court ended up doing. So the court did grant defendant's second letter and said that they will consider the entire motion. So he ended up winning that, where now they're not just going to have to rely on the first motion that may have been a little deficient because it was rushed, according to them. So they made more of a cushy motion. But what's interesting is that Brian Ponder has withdrew from this. They've made a claim that basically, essentially, you said that he dropped the ball. I mean, that's pretty much what they said on this. But he's still representing Whitehead in the civil cases. Now, I'm going to assume that it's contingency, but I don't know. Contingency is basically you run your case and then you get paid when you win at the end. And how we know that is just because he even mentioned upping a case because he filed a defamation case against Miss Jones and the radio personality over there in New York and the company. And he's upped that lawsuit because he's gotten the transcripts so he can put more direct quotes in there. And he's beefed it up. And I guess he's asked for more money as well. And he just filed that on Friday. So he's still representing him on some civil matters. So NFL White says, I think this Ponder withdrawal was part of Don Florio's playbook. So you have a question, Jeff. So could the reason for Ponder leaving is not because of non-payment, but he knew they were going to bury him? Will he be able to refute these charges? Well, I don't think he has anything to refute right now because it sounds like the judge just doesn't even want to take that gamble and just wants to go ahead and let them, they'll consider the whole motion, and then if the government needs to respond, they're giving the government time to respond to that whole entire motion that relates to the entire indictment instead of that one count. Chosen One says, I think that a wise attorney knows their capabilities and accept cases accordingly. Thank you so much. Yeah, yes, definitely, because I would be a better attorney. One of you guys, because you guys think very analytical as well. I don't call you the intellects for nothing. Some of your questions are very intriguing to me. Some of your observations and analysis are very intriguing because you email me. You guys DM me. And plus what's in the comments. I go back and I'll go in the comments. And I think one of you guys who may not have a legal background, but for Law and Order or some of the shows that we watch on TV would be very, very beneficial because you'll probably catch a lie that I might be writing at the time, preparing for my cross-examination. You might remember that you read a transcript, and that this person needs to be impeached, which means that they were dishonest on the stand, and I need to bring up that dishonesty. There's been a lot of times that my paralegal noticed things, and she writes a lot of the motions, the facts, prepares you, and all of that for trial. So she's very, very intuitive. We always say she just got half of her bar card numbers because she just need the other half of the numbers. So she's very intuitive. So she'll sit there and she'll hey, and write, a bunch of notes. So yeah, it's very, very helpful to have more people that's there. But anyways, that's that. So I wanted you guys to know what occurred with that situation. So that was his good news. They were able to, get their full emotion. I will have to see what the judge decides on whether the court is going to allow the suppression or no. Now, many of you have been asking me about, well, should I start with that? I guess I'll end with Glory God because we already in 50 minutes. That went by really, really quick. So yesterday, I don't know how many of you guys watched Tasha K, but on her app, she did about a 13-minute segue on Whitehead. And I just want to say, Mr. Whitehead, I don't know why you going off on me because I remotely never just even said any of those things about you. Like, that was supposed to be your friend. I thought she was very clear that was not her friend. And she made it very clear during that. She made it very, very clear during that. So anybody, it's not on. A lot of times she'll put it on YouTube after she puts it on her app. I don't know if that's what she plans to do, but it's currently on her app. She had a lot of things that she had to say. Some of the stuff I don't even want to repeat because I don't want some of these people coming after me. But she did mention how, Whitehead wanted her to do the story on Belmonte. We all know that was supposed to be the person that he's saying set him up. That is also in the indictment, the businessman, according to him. And she basically was like, so you want me to do witness tampering? Like, nah, I'm not doing that. I don't play with the feds. So she was like, yeah, no. Then she talked about how she doesn't really talk to him anymore. He was blowing her phone up. She has a lot of information. She mentioned Foxy Brown and some stuff allegedly with Foxy Brown that I ain't gonna repeat. And so it was just very, very interesting to see her commentary on Whitehead. And she also mentioned, what else did she mention? For all those that watched it, I'm trying to think of all the other stuff she talked about, but it was only that segment was probably 12, 13 minutes, but she really was laying into it. She was laying into him. So, and she just was saying, that's why I told him to be quiet. He talks too much. I mean, some of the allegations was like, oh, okay. And she did mention the church. Those facts where I wasn't really like following, because a lot of stuff with the church, that's why I said I may have to do a separate video. People get it confused because I've been very, very clear and on purpose to say there were issues with that ownership before Whitehead even came into play. That's why it took me so long to figure out what Whitehead had to do with it, because all the documents I had everybody's name but his. So that's why I had issues with it. So as you guys know, as it pertains to the church, everybody is pretty much in litigation now. So you got Glory of God has sued the 5904 Foster Trust Avenue. Since then, Whitehead then changed the deed for 5904 Trust, the Leaders of Tomorrow. Once he did that, Moses, who is the one that bought the building at a tax foreclosure sale, he's filed a lawsuit against Leaders of Tomorrow. And so that is the most current one, where he's basically saying that it was fraud with him transferring the deed. So there's so much going on, as you guys know. I'll give you the content, but if I feel like it's going to affect somebody's ongoing case, I'm not going to do it. It is so much stuff with this deed going back to 2018-ish, and it's all over the place. All these people are connected, and I have lawsuits against the people that allegedly took the building originally from Glory of God. There's lawsuits out there against that company. There's deposition transcripts. The attorney that's representing, I think, Moses, I believe, is the same attorney that's representing the person that originally took the deed in 2018. It's so much stuff that's going on here. So I'm going to have to do a second, probably a live within itself, just to discuss that. But what I do want you guys to know, because I've seen that a few people emailed me this order that came down on Friday, I think it was. And there's been a misunderstanding on what it means. So Mrs. C said he knows Tasha K knows things that can really take him down, so he won't speak her name. That's what I'm saying. Like, I'm coming with documents. She was saying some stuff. Now, she said allegedly, but it was like, whoa. And she mentioned like Belmonte alleged, I guess he's supposed to be, he owns some luxury car cars, as we know, and he will rent them out to rappers and then put wires in the cars. And then that's how a lot of these rappers got caught up, allegedly. So I don't know if that's information that she got from him or got from, some other source. But yeah, it was. I wonder if he found the kindred spirit in her and told her things and told the truth about things. I don't know, but she made it very. She also said that like he would be calling her via like Instagram and WhatsApp because he was saying that his phones were tapped. And yeah, because it was a lot in that little 10 minutes. But y'all, I'm waiting on him to have a rebuttal because he quick to talk about us. I don't know. That's when I'm sitting back. I'm like, how many think in this chat? I should have did a poll. How many think that he's really gonna come back and say something to Tasha K about what she said about him? I'm not too confident that he's gonna do that. He is threatened by an intelligent woman. I don't know what his problem is because I surely was. So you guys think he's scared of Tasha K? She knows the dirt. He skips right past her name. I noticed that people will say they'll bring her up in the comments and he never brings her name up, which is interesting. It'll probably come on YouTube because literally it's only, like I said, 12 to 13 minutes is that segment. But she did say she's going to do a series. She said she was going to do, what she say, pastors, prophets. She say prophets, pastors, and predators or something. I think she called it. So she said part 2. So I don't know if she was joking or she was serious, but she made like she's gonna end up doing a whole series on it. He said, "Now I'm gonna pay $12 to see what she said." She said that whoever owned the property signed over the deed to criminal head. Yeah, that's what she said. It was like, no. I think her rendition of it was just what you said, that the owners needed money to refinance. And so while they were trying to get refinancing, they signed the deed over to Whitehead. But we all know that the owners just got it in a tax foreclosure sale and they paid like 1.9 for it or 1 point something or whatever they paid for it. So we all know that wasn't. That's why I said when it comes to the church, I think everybody is confused because it is confusing. The only straight up information that we know about this church is that these individuals that was there, and I can tell you they were paying whoever they were paying to stay there, or the mortgage company. I think it was the first mortgage they were still paying while they were there. They were doing that up until their attorney was like, why are you still paying for this? Like, the deed isn't in your name anymore, so why are you paying for this? So, and they sent canceled checks to me, and I was like, you don't gotta prove nothing to me. I believe you. I don't no reason not to believe you. And I think it's because people were saying they weren't paying to be there. But then you also have to remember that they had to make repairs. They kept up with the place. They put in expensive sprinkler systems that the city made them do. And I'm like, they did all of that while they were there. So clearly, I don't know what the arrangement was where perhaps I think they were trying to refinance. I don't know, but it's a lot that's going on. But I know that because we have so much litigation, I'm going to have those answers real soon for you guys. So I don't really want to speculate. I just want everybody to know that they were lawfully where they were. And they had an order that they could stay. They were occupying it and they had an order that they can stay from the court. So he said Tasha is foul. Well, she said she ain't got no friends. Everybody knows when it comes to this, she don't have no friends. That's what she said. And while he was bearing his soul to her, she was probably, and she said, if I know all the stuff that I know, then you have to know the feds know way more than what I do. That's what she said. Tasha K beat him and left him defeated. Dev heard it. I was like, do you hear this? Oh my gosh. She's upset because she thought like he did that they could trust each other. When he referenced her as a source of his rants against Larry, she became upset. She mentioned that too. So you guys are triggering my memory. She did say that he thought it was some type of collaboration, and she's like, this my thing, like you don't got nothing to do with it. You can't dictate how I do my interview. You can't dictate how I choose to do my interview. And at one point she wanted to be like, if you don't be quiet, I ain't gonna do the interview, type of a deal. So that was part of it too. He really thought he found a friend in her, is what it sounded like. But I'm just a spectator. I just stick to the documents. That's why I said, well, what you mad at me for? I'm sticking to the link. If you got something in your documents, I'll put it up there. If you win, then I'll put you won. If you lose, I'm gonna put you lost. If your motion got denied, I'm putting it up there. If your complaint sound a little I'm gonna say, in my opinion, it sound a little That's just what it is. I think I was very well rounded. Now, if it tips on one side more than the other, that's not my fault. That's just the way these cases are falling. But to make it as if it's some personal thing, like you get personal and surface, you name calling, it ain't that deep. It's not that deep for me. I'm really just going over the documents. And guys, I don't make no thousands of dollars. I don't even know where that came from. And I want to know the content creator that does, because I need you to email me and tell me what you doing that you making thousands of dollars and I'm not. Hundreds of thousands of dollars. So, Whitehead said that too on the live. What'd he say? I done missed it. Everybody see want to see me. Well, y'all gonna have to wait. Hopefully she put it on YouTube. Oops, they did say there was no micromanagement on their part with Ponder. However, I'm nosy and would be reading everything. Tasha K is where Bessie resides. I cannot watch the mess. And she kicked his back in and destroyed his 10 nose dive. Why did Gloria guys sue Mr. Moses? He made Whitehead trustee. So Gloria of God sued 5904 Trust Avenue. So that would be whoever is the trustee. Because if you look at it, they were occupants they have their own issues with the deed. They've just been having issues with that deed. Like I said, as far as ownership. But as far as occupancy, let's just say Moses is being very, very careful with how he's wording and phrasing things, if you notice. In that limited, that's why I'm looking side-eyed at everybody. So, in that limited trust document, they gave him permission to do two things. To lawfully evict him. I think they were very, very specific to say lawfully evict, because who just says lawfully evict? It seems like that would be obvious that you lawfully evict somebody if you had a right to evict them. My issue is, what did you need him to evict for? If you're the owner, what did you need him to do it for? Secondly, it says to get financing. Why does somebody, when you bought your house, anybody on here who is a homeowner, when you bought your home, did you have to somehow become a part of that property first? Or did you go and get your financing? You just went and got your financing, said, here's my pre-approval letter or whatever that you need, and you get your house. So that never clicked in my head. Why would you do a limited trustee for him to evict, which you can just do yourself, and also for financing? So it had to be something that he told them, I would assume, that, like, because you don't need that to get financing in my mind, unless there's something I don't know, because I don't profess to know everything. But I thought that was odd. So that's why I said this whole situation, even with Moses and Whitehead and all them, is just a little odd. I think all of this is going to come out because, tell you why it's going to come out, because as most of you guys know by now, because you sent it to me, there is a hearing that is coming up where, let's see, there's a hearing coming up. You have Michael Moses, who is suing Leaders of Tomorrow International Ministries. Okay, and it has, upon reading and filing the annex affirmation of Michael Moses as trustee of 5904 Foster Avenue Trust, dated April 26, 2023, by and through his attorneys, Lawrence Kulak Esquire, dated April 28, 2023, and the exhibits annexed thereto, and upon all the pleas and proceedings herefore to it and herein, and sufficient cause appearing therefore. I mean, what is the necessary? All this herefore is hereins and therefore. Let defendants, Leaders of Tomorrow International Ministries, Inc., and Lamar Whitehead or their attorneys show cause as, and then it has the location in the Supreme Court of State of New York, County of Kings, located at 360 Adams Street, Brooklyn, New York, on May 24th at 9:30 a.m. Or as soon thereafter as counsel can be heard. Why an order should not be entered pursuant to CPLR Section 6301, granting a preliminary injunction in favor of plaintiff as against defendants, Leaders of Tomorrow International Ministries, Inc., and Lamar Whitehead until the outcome of trial, enjoining defendants from taking any action with respect to the sale or transfer or encumbering the real property located at 5904 Foster Avenue, Brooklyn, New York, and B, for such other and further relief as this court seems just and proper. So these are the issues. When there is a hearing on May 24th, just to bring clarity, because I had a couple of people asking me about this document. On May 24th, 2023, there is supposed to be a hearing, and he has to show up and show cause, which is basically you're going to do an evidentiary hearing pursuant to CPLR Section 6301, why there shouldn't be a preliminary injunction granted against you. Right? That's what you're going to show up for trial, until trial, until the outcome of the trial, and joining defendants, which is Leaders of Tomorrow and Whitehead, from taking any actions with respect to the sale or transfer or encumbering the property. Okay, so that's what the hearing is for. But the court also ordered that there was sufficient cause having been alleged pending the hearing. So that the hearing they're talking about is this May 24th hearing of the order to show cause. Defendants, Leaders of Tomorrow International Ministries, and Lamar Whitehead shall be and hereby are enjoined and restrained from taking any actions with respect to the sale, transfer, or encumbering the real property located at 5904 Foster Avenue Trust. So what we will call this part right here that's happening as we speak today is called a temporary restraining order, or a temporary injunction, because when it comes to injunction, this would be ex parte. It's one-sided, put in their documents. Whitehead hadn't even responded. We are a due process country. So if they do anything that's one-sided, typically it's just on a temporary basis. So they did this right now. There is an injunction, but it's considered temporary. But then when we have the hearing on May 24th at 9:30 a.m., then once all of the information is put out, the court may grant an injunction. And that would be more like a permanent and preliminary injunction. So I hope that answers your questions, because I had some people asking questions about what it was. And the injunction is for the sale. You see what it says: sale, transfer, or encumbering the real property. So essentially, he can't do anything that has to do with this property. You can't take it, you can't restrain it anyway. You can't do any of that. You can't try to hurry up and sell the building to somebody else. Like, you can't do any of that. Right now, you have an injunction that is against you. And we can look at the affidavit of the attorney This is the affidavit that the court considered when making their decision. Because, mind you, this is ex parte. So when they did it, they had to look at the pleadings and see that there was just cause for this. And they had exhibits attached. They had, of course, the sale deed from the foreclosure. They had, I think they added maybe the trust documents that we all saw in the bankruptcy court. And they also added this attorney did the affidavit. So he says, I'm an attorney at law, duly admitted to practice law in the state of New York, and am the attorney for the plaintiff Michael Moses, trustee of 5904 Foster Avenue, and as such am familiar with the facts and circumstances therein. I submit this affirmation in support of the within application for an order. And so he has the same language, sub A, pursuant to CPLR section 6301, granting a preliminary injunction in favor of plaintiff as against the defendants until the outcome of trial, and joining defendants from taking any action with respect to the sale or transfer or encumbering the real property located at 5904 Foster Avenue, Brooklyn, New York, and B, for such other and further relief as the court deems proper. Then in sub 3, it says the defendants have been notified of the application for a temporary restraining order by delivery of a notice stating that the application will be presented to the court on May 4th, 2023 at 10 a.m. A copy of notice is attached here too as Exhibit A. And then it says like where all of it was mailed to. So hopefully that answers your questions as it relates to what is happening with the deed situation, which I find quite interesting. That if you guys watched the video, I believe that the last one that Whitehead did, the I have a confession to make, he talks about the pastor and him losing property or whatever, and it's so irrelevant to this situation right now. Like, you're not talking about how this man is saying that you fraudulently took, this is what he's alleging, that you, according to the documents, that there was some type of fraud committed regarding you filing that deed that you urged all of your followers to go look on Acres to go see. You told them, go see. You can go look right now. See who owns the property. You can tell. But you didn't talk about that. Like, this man is saying no, but you bring the church in. They were just occupants. They had issues with ownership prior to you coming along that they have to deal with. That has to do with Moses and them. That's why they filed their own lawsuit, because they have their own issues. So let's just stay on task here. I'm going to look at a few of your questions and I'm going to be out of here. We've been over here over an hour. I thank you guys for rocking with me on your lunch break. And I have a 2:00 meeting too, so I got to get off of here. So I'm going to scroll down. I'm so behind on these questions. He claims the pastor sold the church, and he didn't sell the church in 2016, but he did take he did have a second loan that was taken out. I don't know exactly the time frame, but there was a second loan taken out. Kwame said, I have learned more in the past hour than I've learned in law school. Thank you so much. I appreciate it. All right, Jean, thank you for coming on. He said, thanks for answering questions. So May 24th, what is the date? Thanks for your great work and your response. Thank you so much, Harold. I appreciate you. I am considering going to file a deed thingy like Bishop did, so I don't have to pay my money. I would advise, this is my free advice to you, Faith Speaks. I know you got faith, but I would advise that you don't do that, okay? I would advise that you just believe that God is going to give you double for your trouble. He is going to replace everything that has ever gone wrong and taken in your life, and then your mortgage is going to be paid. I'll stand in agreement with you, but I do not want you doing that, okay? That's not a good idea. It's not a good look. It sounds like it's the landlord who's at fault. So, follow the doc transfer, the quickness of transfers, the given reason for the transfers at the time, the reasoning behind the transfer, attorneys involved in any prior yeah, it's a lot. I'm gonna do a separate video hopefully this week. I hope, because it's a lot. to get to this point, but they're all fighting over the deed. Just know everybody is claiming ownership. I guess that's the most general way. Again, before Whitehead even came into the picture, there were issues. So I'm just curious to see how he even finagles his way, in. But to say like, oh, well, he lost the deed, he sold the church in 2000. If he did, what that got to do with you? Let's just assume that he did sell the property in 2016. They were occupants. This is a landlord-tenant issue. They were occupants in the property, and you were advised with an order to turn over the keys back to them. So let's just not get lost in all of the smoke and mirrors. Like, let's just stay focused. Whitehead is a quick talker and probably said he will handle it because he's his slumlord. I meant landlord. So was Gloria God technically squatting as I hear the content creators say? I would say not if they were having order to stay in the property. No, they weren't. They weren't. And they had paid. They were paying money. I literally have canceled. And the reason why they sent me these checks is because people were saying things like that. And I was like, I'm not going to put that up. Like, you ain't got to go fight your case. I appreciate, that you want people to know that you guys are legitimate and you got your own issues on before this tax foreclosure sale even occurred. But no, I'm not going to put that up. I just tell them I've seen them. I've seen years of them from 2016 up to maybe last year, I want to say. It's just like he didn't want to be bothered. He was going to put him to do his dirty work to get his money. If Moses is honest that Limor paid no consideration and he had until February 1st, so I don't see how Limor was it. Meaning, I don't really see. That's why I said I need to see. At this point, there had to be a conversation that none of us are privy to, obviously. There had to be a conversation for him to even be a part of this. And we just don't have that. We don't have the full picture. I think everybody's kind of speculating as it pertains to the situation with Moses. We won't know that. They didn't remember in the bankruptcy court. They didn't really, they kind of laid back if you pay attention. They put in a deed. They showed the addendum that he was a limited trustee, right? That's what they did. But then they never, every time Glory of God, they said, well, this isn't a business trust. This is a family trust. So you can't even do any type of bankruptcy. And then all Moses and them did was concur with what Glory of God did. That's all they did. So they never even went into, you ain't even got the right to do bankruptcy. You never really had a right. And then we never had a hearing either. Because if you recall, when we went over the transcripts, the attorney said he knows he got the right, he has the real documents. That's pretty much what he said. And he'll present them at the appropriate time. So nothing happened in bankruptcy court that we can see what the real deal is. Nothing happened. So we're all just kind of speculating. So hopefully now that he did this deed that was filed, and now they're saying that this deed is fraudulent, then we should be able to see, that after this hearing and some testimony comes, then maybe we'll get a better understanding what was going on. You said you went and got I went and got my financing first and provided my pre-approval letter. Exactly. That's why I was like, why do you have to make somebody a limited trustee? And then I didn't see Whitehead's signature. It was just a lot. I was like, what is this? This addendum thing was just it was interesting to me. So you got financing. Yeah. The statement YouTubers making hundreds of thousands of dollars came from the person that stated he could go to Harvard and get paid hundreds of thousands of dollars. Oh. I don't know, but it ain't true. I'm not benefiting like that now. He knows you have the Coos family. He knows Tasha will get in the gutter with. Yeah, I'm not responding to that for real. I say little things, but not really. I told you, I'm like, this is who y'all want me to respond.
You's a clown. That's what you. Why don't you call me a cardboard bishop now? You tough. Call me a cardboard bishop now.
He's not gonna call you that.
Huh?
I'm not gonna call
Look on Facebook Live. Call me a cardboard bishop now. You clown. That's what you are. You clown. That's what you are. Why don't you say what you say on Facebook Live, sucker?
No.
Got it?
You only ever read a transcript to us to explain so we could all understand you never did anything to that man. That's what I didn't think so. Because you guys cannot possibly imagine the people that have talked to me or the people that inbox me or the people, I don't even use Twitter. My sister-in-law started Twitter and was like, you need to take this Twitter handle for the intellects. I was like, okay, so she set it up. I just recently started coming on there because some of you all share my content on Twitter. And I'm like, dang, I ain't never even on here. So I try to go on at least retweet and all of that. But if you see, I literally just said, well, she set it up probably a year ago. When I did my YouTube channel, she set up the Twitter too and was like, you need to do both. So that's why I even have a Twitter. I got inboxes there from people that got complaints. And it's like, some of the things I said, I could have a field day, but I'm not going to do that because that's not what I'm trying to do. My thing was to find, he just happens to be a situation that has multiple cases. Okay. So on this channel, when a case comes through that we want to analyze and go through, that's what we do over here. You can read my trailer. That's the point. It may be something in your local area that's important that you want to get out. You know, the Shanquella Robinson, I know it don't get as many numbers or whatever, but it was very important to try to get out for people to know what was going on. You know, so that's what we do over here. It's not just you. You just got so many cases. That's it. And we're trying to get through the cases before, 3 years from now. That's what we're trying to do. But yeah. The devil is a liar. That's that ring light. Don't say that again. Yes, I am going to try to do the YSL. Many people have asked me about that. I guess they'll eventually get to trial. It's so many twists and turns. What I didn't want was when I seen how big the indictment was, because it's a RICO, I was concerned that I was going to start learning about one defendant and they was going to snitch, and then that was going to be a waste of my time. So, yeah. Title fraud is very prevalent in our country and they running amok in New York. That is true, because there was a lot of articles and cases on it. It's clear how them taking out a second mortgage set up for that company to steal their title deed. They had a second loan they took out, and that's how all this started tumbling. And then the fact that the first mortgager know the second mortgager is not by coinky dink, in my opinion. So that's why I said I'll talk about, yeah. So anyways. But anyway, guys, I have a 2:00 appointment, so I got to go. So I thank you guys for let's put the cash apps up here. I appreciate it. Let me see. I got to get some music. That's just so dead, ain't it? I know. Sheila, thank you. Beverly, thank you so much for the cash apps. Thank you for all the super chats. Thank you guys for rocking with me. And until next time, I'm going to let you guys leave out on my son's bop. This is the only bop I have is my intro. So.
Yeah. So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit of accomplice or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge. They don't know they missing. Got a couple current events that you like. Wanna know about law from the eyes. Tired of all these blogs running lies because they agendas are disguised. Tune in to the intellect, cause Cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.